A very good evening to you. Thank you very much for keeping us company. We are heading straight into the Family Matters segment tonight. We are talking about succession. What is succession? A will. Do you know what a will is? Have you written a will? Are you in someone's will? Are you challenging a will somewhere? And in studio tonight, I am joined by two lawyers and Lady Justice Abida Aroni. Thank you very much for coming back to the program. Thank you. I'm glad to be back. It's been a while, some months. Absolutely. Karibu sana. Asante. Yes, and then we have an advocate of the High Court, Joram Mwenda. Thank you very much. Have you ever been to KBC?
Thank you. This is my first time in KBC.
You're welcome.
Thank you.
And counseling psychologist Jane Ngatia. It's been a while since you were here. What have you been up to?
Well, a break is good sometimes. I've been breathing.
All right, thank you very much. And Hosea Manwa, an advocate of the High Court as well. Thank you very much. Many Kenyans have been treated to a lot of news around succession. We know that your division handles so many cases. We'll get to that. But let me start with the lawyers, since it is them who take up these cases and bring them to you. And then we'll go to Jane Ngatia. She understands matters to do with psychology. I know that this has a lot to do with psychology. Hosea, what is a will? Let's start from there.
Thank you very much, Edward, for having us on your show this evening. I think a will is the wishes of any other person that he documents or states to the people that he leaves behind before his demise, that will now inform as to how his estate or her estate is supposed to be distributed once he dies. And so it's basically the wishes of the person as to how their property is supposed to be distributed to the dependents or to the people who he thinks his property should be distributed to. So essentially it's basically the wishes of any other person that are documented or not documented that should come into effect after their death.
All right.
Yes.
Lady Justice, we have seen cases, involving will and succession come to court. Why do they come to court? Isn't this something that probably families can sit and decide that we have a will with us, let us obey the will and not take this matter to court?
Thank you. It is inevitable where there's a will or where succession comes into play that parties do come to court to obtain probate or grant of letters of administration. You cannot administer the property or the estate of a deceased person without getting the necessary permission through the court. So whether there's a dispute or not, you must pass through the court to get the permission to administer and after process to distribute the property of the deceased. And there are very many reasons apart from the administration of the estate that we find litigants coming to court. Some complaining that they have been left out of the will or they were not adequately provided for, or where they cannot agree on distribution. Right. So it's not that they come to court because they have a problem, but the law requires them first and foremost to come to court and obtain permission to administer the estate.
All right.
Yes.
And we have seen cases where people challenge wills. How many are there many cases that the judiciary is handling right now?
Well, a sizable number, yes, unfortunately. And for many reasons, like I said, some because they have not been provided for, others feel that they have not been provided for adequately. Yeah, so I think it's normal. It's normal for some people who are aggrieved to come to court and seek recourse.
Does someone walk away saying that I have won the case, or the judgment does not necessarily need to go that way?
It depends. In court, there's always a winner and a loser. Although increasingly we are moving towards mediation, court annexed mediation, where we're trying to see whether families or members of families would walk away with a win-win situation where they sit and are able, with assistance, to arrive at an agreement.
All right. Joram, have you had cases where you have to defend a client in court and the case has to do with succession?
Yes, I have quite a number. And in most cases you find that, just like the judge has said, it is a family member feeling aggrieved by the decision that was made either by the deceased or where the deceased did not leave a will, what the family is proposing to do with the property. In that case, then the person who feels like I'm not getting my fair share of what I'm entitled, when the time comes in court, they will definitely petition the court and hear their grievance, and they expect that the court will look at it favorably or fairly and then give a decision. But as judge has said, in many cases there are no winners or losers in family cases. Of course, if you don't get what you want, you feel like you have lost. But in the bigger picture, we're trying to encourage families to go for mediation and even sometimes arbitration, so that they're able to come up with their homegrown solution. You see, take for example, you are sharing a piece of land.
Yes.
After the acrimonious court process, you're going to be sharing and living together as neighbors. Now you can imagine if the cow crosses over to the person you feel wronged you, even got a benefit in court. Of course there will be a problem. So we try, when you have mediation and people feel like they have gotten a fair chance and put their things in order, you have good family relations. So that's where we head to.
And talking of families, I know that Jane Gatia deals a lot with families and counseling. A family has gone to court. Probably brothers have been battling over inheritance. And now the court has decided that this one takes this and the other one takes this. But at the end of the day, you're still brothers. How do you come together and say that whatever we were fighting over is behind us and now we need to forge ahead?
Wow, that's a very important concern, Edward. And considering that counseling psychologists are very concerned about family unity. And if there's anything that threatens family unity, we must get there somehow. I say must, because we want to see that if there are matters of inheritance, as much as we may not go to court and all that, ours is to ensure that peace prevails in the family. Because a family does not stop to be because there was no living will, or the will didn't favor one member of the family. Because ideally, psychologists want a family to operate like a unit. Ideally, it's like a system. And if there is something that offsets that system, then whether the will goes whichever way, east or west, there will still be a problem. But also psychologists encourage that when families take each other to court, it is important that they still sit back, sit together after that and do something like reconciliation. Yes, I didn't get what I wanted, but we still live as members of the same system. And that is very, very important. But we do also encourage people in a family setting, particularly if there's an elderly person, head of the family, or someone who seems to have the property and has the power, and probably they are, they could even be terminally ill. We help them and we suggest that they ensure that they have a living will, because that eases the burden of the family members. Whether they go to court or not, what matters is what does the family want, and have they agreed? Did they even talk to the person who seemed to have the power over the property available.
So, Hosea, at what point are we supposed to write a will?
Wow.
Well, that is an interesting question, considering that we live in a society that actually condemns anyone who writes a will. I believe in Kenya there are tribes where writing a will, it's an indication that you're going to die, and it's
even insurance.
It's presumed as a bad omen.
Yes.
And so I think anybody can write a will at any time as long as they are beyond the age, the capacity age, that is 18 years. And they own property or they have anything that they wish to actually allocate to someone else. So there is no specific time that has been put in the statute that by this age you're supposed to have a will, or you need to have a will, or you can write a will. You can write a will at any point in your life based on how you feel, because essentially the writing down of a will is to ensure that at the moment when you're not there, when you're deceased, your property will be bequeathed to that person that you wanted to actually have that property. And so anybody can write a will at any stage in their life. Usually, most people do wills, and it's very unfortunate in our country that we find people when they're in their deathbeds or they're sick, or when they are met with certain catastrophes, that is when they actually draft a will, which is a very bad tendency. I believe any other person or any mature person of age should actually endeavor to ensure that he puts his house or her house in order by actually ensuring that he documents or she documents how they intend their property to be distributed up once they are normal. And so there is no clear stipulation under the law that requires you to write a will at whatever point, but as long as you have the capacity and you're sane, you can actually do it whatever stage in life.
All right.
Yes.
Lady Justice, what's the point of writing a will when someone is going to challenge it in court?
Like Manwa says, I think it is important that when you're an adult of sound mind, you should put your house in order and you should write your will. If the provisions are reasonable and you provide for your dependents fairly, then you hope for the best, that they will all be happy and accept your will. Although, really, you can't stop people from going to court and challenging your will. But I think it's really important to have an organized life and to organize your dependents before you pass on, and be fair and declare everybody, so that some people who depended on you while you're alive are not left out in the event that you die, and they are not known by the rest of the family. So I think if you do the right thing, there are chances that every other dependent will accept your will, but you can't stop them from going to court.
So if
That's why the courts are there anyway.
so if I write a will and I do not include someone, a dependent of mine, in that will, he or she can still go to court and the court will rule in favor of him or her.
It's actually the law that if you leave out your dependent, they can actually go to court and seek for reasonable provision.
All right.
So it's a requirement of the law, unlike law elsewhere, where you can, for example, decide to leave all your property to take care of a cat or a dog. It doesn't happen in Kenya. You must think of your wife, your children, and other people who have depended on you.
All right.
So you have the will and the freedom to dispose of your property, but every right has a limitation. And that's the sort of limitation that you get when you're writing a will.
So is it a must win? If I am challenging a will, am I guaranteed a win in court?
No, you are not guaranteed. It depends on the reasons for challenging the will. There are many grounds for challenging a will. One is a will must be written by somebody who is sane. So if you are not sane when you are writing a will, then anybody challenging it will win. If you are intoxicated and the day you did it, you are not in your senses. If you are coerced into writing a will, possibly you've seen that. If you are threatened into writing a will, or undue pressure was put on you to write a will, all those are grounds for challenging a will. As the judge has said, when you're writing a will, think about all the people that are your dependents. And the dependents are provided for in law. They include your wife, your former wife, right? Your children, biological, those children that you have taken into your family and cared for them, educated them, etc., etc. You can't leave anybody out. The next thing is, if you are not fair in what you do, you decide your son, who has been difficult, you don't want to give him anything because he has never obeyed you. Then, when time comes, your son will go to court and you disrupt everything. So when you are writing a will, the will is challenged at the writing. If you write a good, proper will that takes care of your business fully and conclusively and makes fair provision, it don't have to be equal, but fair provision to every of your dependents, then your will be unchallengeable. But if you wait until you are in a hospital, in ICU, and you're writing a will, we will doubt whether you had the mental faculties. So you're supposed to write your will when you are at your best.
Can someone write it on your behalf? Can someone write a will on your behalf?
Yes.
Can I direct someone? Like, can I direct you to write a will?
Yes, a will can, somebody can write a will on your behalf, but that someone asks, they have to be in your presence. For instance, if you're not able to write, and you have your dependents, and you have the other people within you, you can actually instruct someone to write as to how you want your estate to be distributed. But there are certain ingredients that go into, and as the judge will actually reveal, there are certain ingredients that they look into before they actually confirm that indeed this will is should be enforced. And for a will to be, referred to as a will, it has to meet certain threshold. For instance, if somebody is writing to you, there ought to be witnesses, 2 or more witnesses within that environment, even as you're being helped. And then there is an executor. There ought to be those witnesses ought to sign. For instance, under the Succession Act requires that a written will ought to be executed by those by all the parties, including the person who was the testator, or rather the person who's giving the will. And so those ingredients ought to fall into place. Even as somebody is writing the will for you, you ought to be in that presence for that will to stand. We have had cases where people write, people cannot be able to even write a signature, and so they are helped to do that. There are situations where people don't even have the fingers to do that, and so it now behoves somebody else to actually assist that person to ensure that will is properly in place. So somebody can do it for you, but it ought to be in your presence.
All right, Ngatia, they've spoken about someone being in the right frame of mind, or someone not being in the right frame of mind. Which is the right frame of mind? One that cannot be challenged, that cannot be taken before the Lady Justice by our lawyer.
Yeah, we always consider, is that person, first of all, are they of age? Because also psychologically, age has a lot to do with the person's ability to make a decision. So if they are in a position to make a viable decision, a decision that has, makes sense, logically you can probably understand that this person is aware and fully aware of what they want and what they are talking about. To me, that is a person in their sane mind. And again, if they are not mentally ill, because a person could have a mental illness, they could probably even be suffering from a mood disorder that determines the way they feel at a particular time, and they may not be able to make the right decision. If they have another kind of mental illness, like let's say schizophrenia, that is not a person who can be trusted even to talk about the will at that particular time when they suffer from a mental illness. So there are always those areas that a psychologist will be able to assess, listen to the person, are they aware even of themselves, of what they are talking about? And that way we are able to judge that that person is actually aware of what they are asking for.
All right. Lady Justice, the judiciary has come under a lot of pressure over the last few years. That cases do take a lot of time. Of course, the judiciary, we don't see you guys coming out to talk about these matters more often. But whenever a communication is given out from the judiciary, it's always detailed and giving reasons as to why A, B, C, D is happening. But have we had cases probably in your division that have taken so long to determine?
Thank you. Before I answer your question, I want to just bring to our attention the fact that not all wills are written. Mm-hmm. You can also have an oral will. Yes. Where you declare your wishes in the presence of two people. Mm-hmm. And the will remains valid for at least 3 months, before your death. So having said that, yes, there are many old cases in the judiciary, and in the last couple of years we've tried to see that we conclude them. We've had service weeks where we fast-track cases. But when it comes to family matters, they take long for many reasons. They are emotive, there are a lot of interests, and we have some cases dating back 30 years, and the parties are still in court, going in circles. And it takes more than the judiciary to be able to finalize matters. Succession matters keep, coming up. You may make a decision today, tomorrow it's overturned. So I think it will take the will of the litigants, lawyers, and the judiciary to be able to conclude. We are working extremely hard. It is difficult to convince, but I'm sure lawyers and litigants know. In fact, many a times I wonder whether there is any public agency that works as hard as we do. We are there very early in the morning, we leave late in the night, we carry files home. But it's all in the name of serving the public. We try, but it takes more than the judiciary to conclude cases.
You mentioned lawyers. We have had cases where lawyers are accused of bias. In such cases, is it true that some lawyers are, not all, but some, are biased when it comes to matters to do with succession?
I do not know in what context you say bias.
Let me rephrase it. Are some lawyers, used badly?
Well, as Judge has said, it takes the family, the lawyers, and the judiciary for a case to be concluded within a very short time. Now, take a situation where some family members are sitting at the end of the table, and they already have access to the kitty, and they are able to give you small bits here and there. Would they want to vacate that table? Of course, the answer is no. They want to continue enjoying the bigger portion and throwing morsels to the other dependents. In those cases, you find that, yes, there could be a situation where if you insist that we must proceed to hearing, they just change advocates. And the next day, they appear before the judge with a new advocate who says, I've just come on record. I do not know the reasons why the clients have changed from the previous advocate, which they will not tell you why they are leaving one advocate to another one. And they say, Judge, I need time to look at the file. Now, if the file is 10 volumes of 1,000 pages each, of course, the lawyer needs sufficient time to look through it. What happens next time the case is coming for hearing? he has also been fired again, they have a new one. So there are all manner of things that can be done to drill the case. Remember, under the Constitution, every party has a right to an advocate of their choice. So as much as judge wanted to move on, if you need an advocate of your choice, the judge has to give you time. So that way, the case can take on forever. Sometimes other factors beyond the control of even lawyers and judges arise. Parties can be sick, and sickness can go on for quite some time. Or the day you are scheduled to undertake a trial, people are traveling and something happens and they don't make it to court. So there are many things that contribute to the delay. But in most cases, it's the will of all the parties to move expeditiously that makes it possible for cases to be concluded. We have had very big estates concluded in a very short time because everybody wants this to be done, dusted, and closed in less than a year. But you see, we also have statutory time rights. When you file your petition, there is a period for the documentation to be done, gazetted in the Kenya Gazette. We have no control of the government printer. If he is very busy, he can file your work for 6 months. Then after gazettement, you have a waiting period of a certain period of time, and after that, the other steps take on. So there is a combination of many factors that prolong the succession cases. If you are filing it today and proceeding, on the normal course of business without having to rely on gazettement, the duration that you're supposed to wait and all that, it could be faster. But of course, the law is set in such a way that the gazettement is important to inform the world and the public that the estate of so and so is being administered by X, so that they can bring their claims.
And then probably the judiciary has a very strong defense when it comes to matters delay, because as he says, there is a lot of paperwork needed. The government printer is also involved. Most of the time when we watch news, even our journalists, when they go to court, the stories that come back to the newsroom are just about cases. So-and-so was before the High Court, or so-and-so was charged or was released on bond. But why can't we have probably the judiciary open up so that it's not just what happens in the courtrooms, but administrative side of it, so that Kenyans can have this clear picture of what the judiciary is handling?
Thank you. I think it's a process, and we've come a long way as a judiciary to open up, to be transparent, and to let the citizens or the Mwananchi know what is happening. Yes, I agree with you. We need to speak out more. We are trying. I mean, for a judge to be in the studio never used to happen before. Yes. I think the administration is opening up. We are seeing the judiciary speak more to the public, but the nature of our work also does not allow judges to be all over the place. But it's a good idea to let the public know that the blame should not always lie with the courts, that there are many factors that contribute to delay in matters.
All right. Ngatia, we have seen cases where people who owned so much, their kins, spent so many years fighting over their property. And then we have those people who have had humble beginnings, they lived humble lives, and when they depart, we don't see their families fight over property. Does it mean more money, more problems?
Well, very good concern there, Edward. And if I may talk about that from the psychological perspective, people have different attachments to their wealth, or what they perceive as wealth. And so they will fight for that which they think is of very high value to them. It is the meaning and the interpretation. But while we are still there, there is something we call persuasion. People can be persuaded even to change their perception. because most of the fights, and especially within families and wealth, is about first what they perceive as the loss they will incur if they let it go, and what another person perceives as a gain, which probably is all that matters in their lives. And I'm glad that we have the judge here, because it's high time that we incorporated probably, as he said also, the mediation process, so that psychologists can be more involved to do the persuasion that is required. Sometimes, Edward, it is a very small gap that exists even between families. Take it for instance, these families have always lived together. Members of the family have always been organized. Whether they had much or they had little, I don't think that's really the thing. People will fight over anything, even the least that there is. But if members are helped to see what they started to lose by even taking a long time in that court, they would think twice. And probably that mediation, that persuasion, which can be even done. Okay, I haven't done law, but I believe people can be persuaded, because we also sort out family violence. They don't have to go to court if they are able to agree out there. I'm sure the judge will be saved a lot of time.
Yeah, let me just add to what Mrs. Ngati is saying. The idea of mediation is new. It's been in the judiciary for probably a year now or so. And we encourage a lot of family matters to go for mediation. We actually direct and we adopt the result, if it's positive, from mediation. And you don't have, in fact, there are very few lawyers who join mediators. We have people from different professions who volunteer of a very small fee to come and be mediators in the processes. So it's really a good idea. And even as judges, we try very much to mediate and to persuade families to come together and try and resolve their matters, and only go to hearing if we must.
All right.
Yes.
So I have a legal term here. A codicil. What is it?
Well, a codicil is, I'll just try to explain in the most simplest of terms.
Yes.
It's an addendum or an addition to an existing will. For instance, if today I do a will and decide as to how my property is supposed to be distributed, but in the process I acquire more property and I want to add on to what is already in existence, then I'll do a codicil. It's just an addition, or I'll say an addendum to the existing will. And or maybe I want to
add someone
into
or
the
remove someone.
The will.
Can you
yeah,
remove someone?
Whatever amendments, because the essence of a will is you are at liberty to bequeath anyone or anybody, and you have a right to change your mind at any time. So if you change your mind at any time, then you can actually change the will. Now, a codicil is it's different from making a correction into a will. Sometimes you can actually get rid of the entire will and come up with a new will, or you can actually, instead of getting rid of the entire will, add another addendum to that will in the addition of the property, for instance, that you have acquired before your demise. So I believe that explains what a codicil means.
Okay. Joram, let's say someone passes on, and I'll personalize this one. I lost my father in April this year. Of course, he had his businesses going on. Let's say someone who is in a position as mine where no will was written, but he left property behind. Is that property supposed to be used by someone, or there has to be a court process to allow you or direct you to use it?
In our legal system, we have two forms of succession causes. We have where there is a will, and where there is no will, we say a person has died intestate. So the one who died with a will is testate, the one who has died without a will is intestate. And when a person dies intestate, the process of getting the letters of administration is there. It's provided for in the law. You start with a family sits down and identifies who will be the administrator of that estate. 1 or 2 up to a maximum of 4. Then you go to your village chief who writes a letter to the High Court indicating this is the deceased and the following children, wife and children, or wives and children. And you use that now to go and the following assets. Then that is the basis upon which now you go and start the intestate succession course. So the petition for that one will be prepared and filed in court, and the court will grant letters of administration to the person selected by the family to read the process. If there is disagreement, of course, there will be objection and the usual process will follow. But yes, you don't have to allow anybody or everybody to take charge of the estate. There is a procedure which is set out in law. It just depends on who are the beneficiaries of the estate, and among them you pick 2, a minimum of 1 to 4.
All right.
To read the process.
Okay.
Yes.
I know we have just 3 minutes. Lady Justice, I know there's a lot of succession cases that your division is handling, but which other cases are there in the family division?
We do succession, we do adoptions, guardianship, cases on where people have mental illnesses and they need to have people to help them run their affairs.
All right.
Yes.
And division of matrimonial
and division
property.
of matrimonial property. Divorces, although most of them trickle down to the lower courts.
Okay.
Yes.
So if I want to divorce, do we have prenups in Kenya? Do people sign?
Yes, they
people
do.
sign prenups?
Oh yeah, they do. It's provided for in law.
So if we sign a prenup and probably I don't include you in my will, then you cannot challenge it.
Yeah, because it's really a contract that you enter into just before you get into a union. It must be respected.
All right. It's quite tricky that you can challenge a will, but if you have a prenup, then you cannot challenge. All right. We need to wind up. Any last words? 30 seconds, 30 seconds, 30 seconds, and I'll give the judge 45 seconds.
I think now the ball is outside there to citizens to put their house in order. As the Honorable Judge said, to save the time that we spend in courts and to save individual time and money that we spend in litigating on matters family, it's very important that any person with capacity that is above the age of 18 years should be able to prepare their wills, or they ensure that their properties are bequeathed to the people that they want before that last day comes into play. So it's very important to avoid the last minute rush, to avoid you making decision on your deathbed, which decision will be disputed in court. It's very important that you put your house in order.
All right. Ngatia?
Yes, I've always told Kenyans that there is hope. It seems we have too many problems in the families. Violence, fighting over property, and what have you. And my persuasion to the general Kenyan fraternity is that we put our things in the right place. We need to engage more negotiations, especially at the family level, so that we don't need to spend so much time kissing, taking my brother, my sister to court over things that we could have talked over. That is my suggestion. And also to have psychologists getting more involved, because Kenya is a country that wants to move forward.
All right, thank you. Joram?
Yeah, let's improve our value system. I think one of the things that is bringing a lot of these cases is our decline in value system. Everybody is expecting to inherit. Let's also encourage people to work for their things so that whatever they inherit is in addition to what they have, because when you are inheriting in addition to what you have, the urge to fight is less. Secondly, let us not wait until 10, 15 years after the death of the person whose estate is being administered, because when you bring in more dependents, you know, when a person dies and he left, let's say, 5 children, and they don't take their letters in time, and then by the time somebody is going to court, there are several grandchildren involved, and maybe even a few of those children have died, it gets more complicated. Let us also timeously file or go to court and administer estates as soon as person has died, observe the mourning period and all that, what that surrounds it, but as quickly as you can, administer the estate so that there are fewer people to fight. When you open it to grandchildren and great-grandchildren, then it becomes very complicated. The ones that have been in court for 30 years, judge can tell you, they are complicated by the extents of the extended families.
All right. And finally, Lady Justice.
I want to pick up from Joram. I think we need to improve on our values as a society and the way we socialize ourselves. Secondly, in the 21st century, I think we all need to lead organized life. And writing a will is important because you organize yourself and you organize your family. I think, and in writing wills, we ought to be fair and inclusive so that we do not have offsprings shooting up from here and there. So for me, is to encourage everyone to write a will, be inclusive and reasonable so that you leave your family together as you depart.
All right. Short and precise. Lady Justice, thank you very much. Joram, thank you very much.
Thank you.
Ngatia, we thank you. And Manwa. And of course, these are, I'm sure probably in the next 30 years, there's a case which will still be dragging on, but it is important, what I gather is that it is important for Kenyans to write the will. We forget about our cultural beliefs.
We've moved on in various aspects, so I think we should also move on when it comes to family life. Okay. And not hold on retrogressive practices.
All right. But finally, just yes or no, have you changed your notes? The 1,000 shillings?
I've been thinking hard. I don't think I have any notes. I don't have much money.
Joram?
I changed it the day after the governor said they will not be applicable. And if you gave me the old notes, I wouldn't touch them, but we don't do much in cash.
Okay.
Yes.
Ngati, have you changed your notes?
Edward, I've always been clean.
Okay.
I'm a law-abiding citizen.
Manwa, have you changed your notes?
In the wake of mobile money, sometimes it's very difficult to have the hard cash, so I don't believe I have any old notes.
All right. I don't have the many notes, but we do thank you very much for keeping us company. That does it for Family Matters. My name is Edward Kabasa. I wish you a very prosperous week ahead. Good night.